coming, and I'm really happy that you are not afraid of interactive and participatory work for today as well. It will be very challenging to lead a workshop in this setting with those chairs, you know, being stuck where they are, but I hope that we will all manage and that we will all cooperate and move around a little bit and be flexible if it comes to the room. So my name is Natalia Mileszyk. I came from Warsaw, where I'm based. I work for the Centrum Cyfrowe Foundation. That should be translated like digital center, but we just thought that, you know, it sounds pretty lame in English, so we never translate it. So it's Centrum Cyfrowe. It's Polish-based NGO that deals with digital affairs, of course also platforms and the impact that platforms have on our society. And recently I was also, and I'm still very engaged in copyright reform that's going on in European Union, but that's pretty boring topic for me already. But if you want to discuss it afterwards, I'm happy to. Thankfully, I won't be alone today. Few words, or everyone knows you already? So you know Rocco and Aleksandra Kuczerawy. She is also Polish, as you can hear, so she will introduce herself.
Thank you, Natalia. That's useful to have another Polish person introducing you. Thank you for having me. I'm a postdoc at the Center for IT and IP Law at the University of Leuven here in Belgium. More? Thank you.
So the idea is that we will be working today in 6 groups on what values and what rules we should apply to all platforms, no matter what platforms we are talking about. I hope we will be able to get to some more general conclusions that will lead us further during the day. But before we start with Aleksandra, we wanted to share with you 2 examples of things going on if it comes to platforms regulations right now. One will be European case, and the second one is a short Polish case that I found really interesting, and probably you didn't hear about it yet because Polish language seems to be still a secret language, I don't know why. And afterwards we'll split into groups and we will get to some conclusions, hopefully, because my idea behind this session and why it's workshop session, I simply believe that they are not expert on platforms yet. You know, this trend, like the change in society is so new that every one of us has something very valuable to say, and this forum will allow all of us to talk and to share and to also to get to know each other, that I'm really looking forward. So I guess we can start with the European case.
Thank you. So I was asked to tell you some details, give you some information about the recently proposed regulation on preventing dissemination of terrorist content online. The Commission released a proposal in September 2018, and in December 2018 the Council released its general approach. The goal of the proposal is to address the problem of terrorist content disseminated online by introducing certain obligations for the hosting service providers. The proposal talks about particular societal responsibility of hosting service providers to protect their users from exposure to this type of content. It lays down rules for hosting service providers to identify and to remove such terrorist content, but also rules for member states or measures to be introduced by member states to identify this type of content and then which would then be removed by the hosting service providers. Member states are also required to introduce effective, proportionate and dissuasive penalties, including financial penalties, going up to 4% of the global turnover of the previous business year in case of systematic failure to comply. The definition that the regulation uses is very broad, It lists activities such as inciting, advocating, glorifying, encouraging, promoting, supporting, or contributing to terrorist offenses. It draws on the definition of terrorist offenses used in the Directive on Combating Terrorism. But unlike the directive, it does not specify that the content must be actually criminal offense. The scope of the proposal covers a broad range of services, video, image, audio sharing services, file sharing services, cloud services. So that was obviously pointed out as an issue. The general approach of the Council excludes number of services, registries, registrars, DNS, payment services. But the proposal does not actually make any exception for small platforms or small hosting service providers. The impact assessment actually justified that by saying that small platforms are particularly vulnerable to this type of content uploaded by their users. The measures that the regulation introduces, it's several types. To prevent dissemination of terrorist content online. For example, removal orders, content referrals, and proactive measures. The removal orders would come by competent authorities, and they would require hosting providers to remove content within 1 hour, so very fast. There's no need for hosting providers to make any assessment of the content, as that would have been done by the competent authority. Competent authority is to be defined by the member state, so it actually does not have to be judicial authority. Content referrals do not require immediate takedown by hosting providers, but instead they are invited by competent authorities to assess the content in relation to their own terms and conditions. So the assessment is delegated to private companies on the basis of their private rules and not on the basis of public law. The proactive measures will require platforms to install measures to detect terrorist content, so automated detection tools, upload filters, possibly also artificial intelligence software. The proactive measures should not, in principle, as the regulation says, result in general monitoring obligation, which is prohibited by the e-commerce directive. But at the same time, the proposal admits that such a derogation from the prohibition may be possible due to particular grave risk associated with the dissemination of terrorist content. The works are moving fast. There is a plan to finalize it before the elections this year. So that's really constantly we have new developments. In January, both IMCO committee and CULT committee released their opinions on the proposals, quite critical. They included a number of amendments and changes, for example, narrowing down the scope of application, deleting referrals and proactive measures. Last week, there was a LIBE report, but it introduced some of the changes, but not as wide as the IMCO committee proposed. So we see where it goes from here, but it will be very fast developments, I think. Thank you.
Thanks a lot, Alexandra. As you heard, this proposal raises several questions and also challenges for civil society, how to address this issue, how to answer for such actions. But this action at least was legislative process within European Union. But what happened in Poland, I will be very brief, is that recently the head of public policy of Facebook has came to Poland, to Warsaw, and he met with the Ministry of Digital Affairs. In Poland we have the specific ministry dealing with digital development. And they signed an agreement, memorandum of understanding, stating that Polish government will set up a web page on which Polish citizens only will be able to appeal from the decision of Facebook not to put back the content that was once taken down. Because as we all know, probably, on Facebook, once your content is removed or taken down or blocked, you can appeal this decision to Facebook. And the Facebook can say, okay, we are bringing it back, or it stays as it is. Usually it stays as it is. And because of the political situation in Poland, as you probably know, we are right now facing some changes if it comes to politics. Right-wing movements were really against Facebook policy to block the content related, for example, to neo-Nazi ideology and so on. So they were really appealing and really making some comments and demands towards our Ministry of Digital Affairs. So what the ministry did was establishing this web page, and once the Facebook says to you that your content will be still blocked, you can go to this web page, you can fill the complaint, but you might think that it will be some independent body taking care of this second way of appealing. But no, this web page that is created by Polish government, by money of Polish citizens, will be simply referring those cases back to Facebook. So it will be Facebook judging their own previous decisions again, but Polish government claims it's the biggest victory ever if it comes to freedom of expression and our digital rights. So saying so, I see that you had various face expressions on this idea. So saying so, Rocco, do you want to add something, or do you have any questions?
I do not have much question. Maybe one word of clarification. We wanted to give you this kind of example as teaser. There's much more going on. Probably we do not know all the cases at the national level, so we are already asking to you to bring it up during the group discussion. So you do not have to discuss only of those two teasers or two cases. Probably the first case is very well known by today, I think. It's really becoming a very important topic in the EU political agenda. But you may know of other policy solution or non-policy solution and so on. So bring them to bear on the conversation now in the working groups.
Yes?
Question. In the actual directive proposal, there's any degree of accountabilities inside? I mean, how many content has been blocked due to that request or not blocked, or which content will be blocked?
Like transparency.
Something like that.
I think there is a mention of it, but it's definitely not specified, and that was also criticized. And I think the amendments of the two committees definitely provided more details and proposed more details on transparency reports.
Yeah, I think the answer to that question actually is the overlap with the e-commerce directive. So, in particular, the liability of the hosting providers is regulated by Article 14 of the e-commerce directive. So, if in our case a hosting provider can demonstrate that it is passive with regards to the content it hosts, then it has no liability whatsoever. I think that's the place they overlap the proposal with the legislation that is in power right now. I guess this is the most important. Yes.
Yeah, I know that Alexandra wants to reply to that, but just to already organize this transition, what we would like to propose you to do now is to split in 6 groups. Natalia,
we have a key how to do so. And we also encourage you to think about platforms not only from legal perspective. I know that we have many legal experts in this room right now, but let's challenge ourselves and also think maybe about, education, what can be done in this field. And this session is, it's like the teaser for the further sessions at Privacy Camp. So be really creative, be open, don't limit yourself if it comes to discussions. Okay, and 6 groups. So the idea is, because the issue of platforms and what platforms change in the society is of course not new, and we have this discussion ongoing with various other Polish civil society organizations dealing with digital rights. And recently we created the set of various needs that individuals and society have towards platforms. And I would suggest us to form 6 groups around those needs. And for each need, we need a leader of a group discussion. So I will be presenting needs, and that's the moment for you to volunteer. I have 2 already volunteers, but I need 4 more at least. So the first need is information autonomy and subjectivity, meaning that we don't have control over decisions that affect our life anymore if it comes to platforms. Who wants to take care of this topic? Okay, first I will present 6 of them. They're there already, but I guess the font is too small for you to read. So the second need is predictability. It means that we should know what platform will do, but usually we don't, because, for example, self-regulations rules are so vague and so not clear. Of course, control over our data. We want to control and to be sure what happens to our data, but it's not the case anymore. We as a society and also as individuals, we want to have open and equal access to various services and various products, but platforms usually, unfortunately, limit this. Instead of making our society more equal, they make discrepancies bigger. Awareness of the rule of the game. Many things happening on platforms, but we don't understand, and we don't have access to data, for example, and platforms are generally not very transparent entities. And very specific one, because elections are coming, transparency of conducting political activities on platforms. So those are 6 needs, and there will be some questions to lead you via this group work, so don't be afraid to volunteer to take one of them. So anyone interested in political activities on platforms? Great. So you can have a look who will be a lead of this one. Great. I will give you a piece of paper in a moment. Or maybe, Rocco, I can help you with distributing those farther down to the room. Awareness of the rules of the game. Anyone dreams about perfect? The lady at the back. Open equal access. Anyone dreams about more equal society? Of course, everyone, but great. We have 2 volunteers. So, Rocco, up to you to decide. Control over data. Okay, Valentina.
That's my job.
Predictability. Very tough word to pronounce. Anyone? You can take this. Great. And information autonomy. Oh, great. And now it's the most challenging part of this group exercise. So you have to find the leader you want to discuss his or her topic with, and simply, form a group around somehow. Like I'm really hoping that you are creative enough to use this space the best way we can. So yeah, maybe put it like up so people can see who has what. Seconds. So time is yours.
Hi. So we talked about information autonomy and subjectivity, problems about not having control about algorithms and their decisions. We changed it a little bit. Actually, it's a problem of personalization as well. It's a bit broader than algorithms alone. And what were the problems there? Well, usually that you don't know what kind of decisions are made on behalf of you or how your weaknesses are being exploited. So as a general rule, we decided that we need something called autonomy by design through a veil of ignorance, where we mean that the weakest person in society should be protected by default the most through interfaces and algorithms. How are we going to achieve this, or how are civil society organizations going to do this? Well, maybe we were all academics, but we decided on more research into understanding what personalization and algorithms are trying to make you do. And secondly, more legal research on what is needed according to law in terms of transparency, explainability, and so on.
Okay, thank you, Rob. Can I ask you to post your recommendation next to the rule, like the need, and also the problems you mapped as well? So we'll have like a short mapping exercise as well. Is there anyone willing to comment on what Rob has just said to us? 30 seconds. Nobody? Anyone? Okay, group number 2. Who was dealing with predictability? Who's presenting? Alexandra?
For some reason I thought we were last. Okay, so predictability. We had a very interesting discussion, and it's a problem that has actually several aspects and several layers. We talked about predictability of rules when you're posting something on a platform, and then you want to know if there is a problem, so in which situations that could be taken down, but also on a higher level, predictability of rules that come from the state. So in the example of the regulation on terrorist content, which has a very broad definition with very different types of content that could fall under it. And here there was several commentators saying that actually it could easily lead to content posted by organizations documenting human rights abuses, which would then be deleted because they disseminate terrorist content. So we have actually a number of posted here with identified different problems and different aspects of predictability of rules. And that the situation when platforms are in the middle and that have to decide on what content to remove, otherwise they could possibly be held liable for users' content, or could be they could have fines which are quite high in case of dysregulation. And in the end leading to over-compliance, so overbroad censorship of the rules.
Okay, so you get extra 20 seconds for the solution.
Okay, so yeah, I think we basically should all do what we're doing and more, so advocating and researchers doing more on this topic. And I think the important element here is for broad public debate and all these groups being involved in the policy making from the beginning. So those aspects could be taken into account by the policymakers.
Thank you, Alexandra. Can I ask the group to post your results around your number 2, okay, if you wrote it down. And group number 3, control over data. Where is group number 3? It's missing. Oh, Valentina. In the meantime, maybe some comments on the group number 2 results. Anyone? Okay.
So we discussed about control over data, tracking, profiling, non-personal data, aggregate data, and we tried to map a lot of the needs and what should be done. A lot of the situations that we faced were that there's a lot of power imbalances between users and companies, and users cannot really have their say and have their rights exercised. There's also a lack of tools that you can use in order to exercise your rights. But coming to the solutions, jumping to the third question, in our group, Bits of Freedom already launched a very cool tool that you can use to send access to data requests, deletion requests to companies. So there are lots of things that civil society organizations are doing on this aspect. We also talked about data monopolies and the fact that aggregate data tends to have much more value for companies than individual data, because although personal data is valuable for us in an economic situation, companies do not monetize it that much, in a sense that it costs a few cents or $1 or $2. But I think we are facing a huge lack of awareness and knowledge among users about how they can exercise their rights and how they can ask for more control and protection and transparency. And this is something that we should be all working on. And also another tricky point is that data protection authorities lack resources to effectively enforce the privacy frameworks that we currently have. So we don't have, we still need to discuss a lot, and we don't have solutions for a lot of the questions that we want to, with the needs that we want to address.
But you have a party to keep going with this discussion. Thanks a lot, Valentina, for this. There is a tape over here if you need it. And any comments or remarks on what has just Valentina said? Yes?
Reflection on one of the, maybe, I don't know if it was like things that civil society could do, but for instance, the freedom of, I don't remember the name, the tool to access what kind of information they have, these companies have. What? Access requests, exactly. There's another one called Access My Info that the Citizen Lab developed, but they only work depending on who asks and in what region. Like if you would ask from Paraguay, they never replied. I did a request, for instance, to Grindr, and they never came back. They never replied my request. So I think that it is important also when we talk about these solutions that we take into account the context in which each of the situations are developed. Because even though I think it is a very interesting option, it doesn't work everywhere.
Yeah, it's really a challenge in globalized internet how to create solutions working for everyone. It's a good question, but maybe next time we should find somebody to fill the complaint on your behalf from, you know, from this territory or something like this, you know, to hack the system somehow. Yes?
Can I just quickly respond to that? My colleague Jeff Auslos did a great research on access requests last year. It was under the directive. I got some awards for that. So you might want to look there. And it's we're doing now the second part where we want to try the same thing under GDPR. So we're sending requests and then we're sending reminders and notifications, and basically we just keep bothering them until there is some response coming. So if you would like to be involved, we will be happy to have another person to experiment.
Yeah.
Our organization, NOID, has filed 10 complaints against 8 companies with regards to access requests. And shortly we will have some results, we hope some decisions from the DPAs. So if you're interested, you can stay tuned.
What's the name again of the company?
NOID. We are based in Austria. Yes.
Great.
So
So many actions going on, that's great, and I hope we will keep sharing our experiences and ideas during the whole privacy camp. So now it's time for Open Equal Access, group number 4.
If you don't mind, we do it from here because we got share pieces of paper with different handwriting that we don't know.
Yeah, sure, but guys, I see that I need a timer for you. You have 90 seconds, so...
Keep it as it shows. So basically, we got plenty of problems, potentially good problems to have, because apart from the plenty of problems, cybersecurity, competition law, non-discrimination, monopoly, data protection rules, consumer rules.
And what can be a solution?
Those are rules. You ask, those are the problems I mentioned before, then we get rules. Rules are data protection, for instance. Now they increase the amount of fines that can be used, so the regulator should use them. We have here joint coordinated complaints, which you just mentioned. That's a way to go about it. The complaint could be mixed competition and competition law complaints. You have also consumer protection rules, so you got the courts, you got class actions, so you got rules which are already there. The question is to implement them. However, with the stick, you don't deliver the result. This is one, the carrot is very important, but it's not the only one. You need the carrot. So we need incentives. And therefore, we need to prepare other perspectives. Basically, we need to create alternative tools, equally funky, equally attractive for the people to get off the habit of saying tick and accepting that their data is sold on real-time bidding by third parties. Yeah, I'm almost there. Then we got, in order to have this goodie work, you need new apps and new services, but they need to work. So you need interoperability, you need net neutrality, so you need to work on these areas. Of course, you can work through the standard ISO, IEEE standardization, we have from histories, so we can learn from past experiences on how, make use of the data and make sure that the people with the awareness that was mentioned before start understanding that ticking the box is not necessarily something that you want to do if you have an alternative. If you don't, I used to use the same internet browser that the competition authorities say you have to have ubiquitous Microsoft with another system. Then you start using another system, but you, lazy person, have to look for the other system, download it. You don't download it, you stick to the situation. So, same story for data protection problem. We are accepting the fact that there is a breach, but hey, this is a cheap free phone call, we go for it, until you start understanding that there is an easy alternative to go for. So there are ways, we need to work all together, and just to make sure that I cover also the other points.
Yeah, I would like to ask you to post all your solutions and things that you wrote down on the blackboard so everyone can so everyone can read it, and I will also take photos of those things, and hopefully I can be able to distribute among people willing to get them. Any comments from the audience?
So just one point.
No comments, no comments from the speaker, but there will be plenty of opportunities to.
You guys are in power, and so what is really important for the company is the trust / stock. So if you start being noisy about the situation, or the competition or the election authorities, you have the power to make this change. So trust, business model, stock.
Great, sounds like a very concrete, very precise action plan. Thanks a lot for this. Awareness of the rules of the game. Group number 5. Where are you? There are 2 groups left. Great. Do you want a tape?
Hello. Our problem is that there is no awareness. So no awareness, the solution is transparency, yes. Good. So lack of awareness is systematic. There's no awareness in anything. So we need transparency, but we need 2 types of transparency. First, the proactive transparency, and then the advanced transparency. The proactive transparency has to be for everybody, was mentioned, the weakest link. So it has to be really from the companies, the controllers, in a natural way that we all get this basic information. Then we had this discussion about the advanced transparency, and somebody claiming that actually the systems can never be transparent because they are magical and they function in their own way, and we will never discover how it works. But we think so some people should try to figure out how the system works, that we can then contest the decisions. I believe that law has some approaches to when we don't understand science or we don't know what is happening, then we can still deal with this question of whether this is fair or is not fair. So we have these 2 types of transparency. In practice, how do we do this? The GDPR is good for you. You should use the GDPR as a citizen, as an NGO, in other ways. So in the GDPR, there are rules on this proactive basic transparency, rules on information. We have to make sure that it's clear for everybody. And then there are also tools, like the research, the access thing, that can be used to get into the advanced transparency and contesting the decisions. And I think basically, yes, also we should be clear that ethics will not save you. DPAs will not save you, so don't give them the money, give the money to us. And that's it. Thank you.
Thanks a lot for this. If you can post all of the results of your work on the Blackboard / Greenboard, I would be happy. Any comments on this? Remarks? Okay, yeah, I know, guys, that I'm the last, person kind of before lunch. So the last group is transparency of conducting political actions on platforms. Coming, great.
So our topic was transparency of conducting political activities, platforms. Our group was the most passionate one, apparently. So we came up with 6 issues, and we had 5 minutes more. We would come with 12 more issues, but we had to restrain ourselves. So first issue is dark ads, micro-targeting and transparency. Another issue is what is the source of the ads? We don't have a clue of what's the source of advert funding directly and to intermediaries. Then is virally shared political content, meaning from users of digital platforms such as Facebook. Then an interesting issue is how platforms make decisions about takedowns of content, etc. What are the criteria used? There is lack of transparency to that respect. Then we have platform support for totalitarian regimes. Like, for example, if you know the Project Dragonfly with China that Google has, this is huge issues we need to see about specifically for political content. And finally, international interference and funds with regards to political advertising and the role of bots and fake accounts to that respect. So these issues cannot be addressed by one rule. However, we come with a variety of solutions that can be consistent in one regulation, on one decision, and so on. So one resolution could be that platforms must follow international human rights law in decisions affecting rights. So the rights we have already are sufficient to advocate for our rights. However, they need to be specialized for the digital society we live in. Second, protection for user data from authoritarian regimes. So even if we are living in a Europe that extreme right is on the rise, and also I'm not sure that safeguarding your data is putting the government on control of the platforms. So you need independent authorities, and you need in a European level authorities that safeguards your data and the content of the platforms that you post. Maybe a public database for all political ads and targeting info so that you can see who funded what and for what reason and from what country. This is of huge importance. I'm finishing. All political adverts must include info of the funder, even either for tax purposes or, but most importantly, for political purposes. And we know that after the Brexit, we had a lot of instances which we are not clear about what was used and for what reason for advertising. Finally, political adverts might only be targeted to a jurisdiction by a legal entity in that jurisdiction. So, for example, I cannot be from the US and support politically or fund political adverts in the UK or in Greece or in every country. To cover the third question, the answer is, we're going to it just a moment, is global advocacy for Council of Europe or UN non-binding declaration. So harmonization, not only in the European content, but international content. We have the same problem with data, with cross-border processing. It's important to have a harmonized rules throughout the world. Pushing for self-regulation, but with safeguards, because self-regulation is overestimated sometimes, as the Privacy Shield showed us. And like the GDPR introduced a novelty of representing data subjects in the context of advocating their rights. However, it's not fully harmonized, and so member states can decide against that. there should be, with regards to platforms, the possibility of non-profit organization represent users and also have the right to initiate their own proceedings, non-governmental organization, in order to advocate sufficiently the rights of the users. That was, thank you very much.
Great, thanks a lot. I hope you will be able to implement all of your ideas before election in May 2019, so pretty soon. But thanks a lot to everyone. Okay. Thanks a lot for these discussions. Thanks a lot for your thoughts. And I guess we simply got very good food for thoughts for the next coming debates, discussions, party, and also the conference to follow. And yeah, simply enjoy your lunch and see you later.